Would you please welcome David Bailey?
Thanks, John. That was a shorter and better introduction than my obituary before. But anyway, thank you very much for those kind words earlier. Now, I have prepared, rather than take you through this very lengthy paper, which came about in this way. I wrote this paper about in 2002, and I thought, being lazy, that I would simply present it today. And then I suddenly came across the fact that the Law Reform Commission had put out a very extensive paper and proposed to reform this area of the law substantially, which meant that I had to completely rewrite the paper. So that's why it's so long. And but if you'll bear with me, I'll go through some of the key points in these overheads. Well, I had the benefit, I suppose, as a young practitioner of having been taught my easements and restrictive covenants by Justice Barnford when she was a lecturer at Melbourne University all those years ago. And I can still almost hear her words ringing in my ears about one of the exceptions to indefeasibility under the Transfer of Land Act are the apparent easements, not registered easements, but ones which might be there through either long user or no one's got round to registering them. But nevertheless, they can still have a bearing on the rights and obligations of the respective owners of the dominant and servient tenements. And what I thought I would do is just to, sorry, I've already got the wrong, here we are, take you through the basic principles, but how some of the things are going to be affected by what the Law Reform Commission has recommended. It was a very high level panel, including Justice Croft and Justice of Appeal Neve, obviously eminent property law experts, so that I recommend the report as a great source of references and authorities for you. So even if the recommendations never see the light of day, it remains almost a valuable text on the subject of easements and restrictive covenants. Where the reason why I think the reference was given to the Commission was that there is this tension, I think, between the old private law rights under easements and restrictive covenants and emerging planning law and problems, of course, as we all know, that Melbourne is growing very rapidly and developments are going on all over the place, and perhaps the way we used to deal with things like restrictive covenants has to change in order to incorporate what is unfolding. And that's exactly what the Law Reform Commission recommendations address. The other thing which the Commission talks about is jurisdiction. Who should deal with things like removing restrictive covenants? At the present time, of course, it's vested in the Supreme Court and the County Court under Section 84 of the Property Law Act. So the recommendation's there to expand jurisdiction. Okay, well now, I've talked about that slide there, so let's go into easements first of all. Again, our old law school days, we were taught that there had to be a dominant tenement and a servient tenement, or one piece of land being, of course, the one with the benefit and the other one which has the burden. Now, we're all familiar with the easements of carriageway, drainage, light, so forth. The question is, will we see other rights emerging, again, as our land usage changes? That's something which the Commission looked at. Now, turning there to where we might see these things go, there's been a lot of writing about whether access to solar energy is capable of being the subject of an easement. And the Law Reform Commission report addresses this issue. It comes to the conclusion that probably such rights are too broad an area to be the subject of a proper grant of an easement. The nearest analogy would be an easement of light, as we're probably familiar with, which is access to light for a window, something of that nature. Whereas with solar energy, of course, one sees whole rooftops in some of the newer houses consumed with solar energy panels. The question is, how do you preserve or protect access to that without unduly creating restrictions on the development of neighbouring properties? So that's one, I guess, that the Commission has identified as an area to be looked at, but one where the traditional rights don't really give an answer. Okay, well, going back to our law school days, there were 4 characteristics of private easements. Had to have separate properties, one which is a dominant and the other one a servient tenement, and there were limitations on the sort of rights that could be attached. In other words, it had to be something which attached and could be defined. You couldn't have rights that were excessive or vague or were not capable of benefiting the dominant tenement in a way which fell within some limitations. Okay, so that's all fine, but how did that work out in the report? Well, the Commission looked at this old question of can you ever have easements that aren't attached to a property and have easements in gross? I spent a fair bit of time on that topic. Now, what's an easement in gross? Well, it's a right which exists which is not attached to a dominant tenement, but it does obviously affects land which could be treated as servient land. Typical example would be a utility company easement to lay power lines, or in the old days the overhead lines. These days sometimes they're underground, but it's a right which is just carved out, usually by statute, to enable a power company to run its power through the streets and across properties and service them. Now, the usual provisions about easements don't apply there because it's a matter of statute law, and or it's something which is carved out at the time of grant of the initial title. But Law Reform Commission recommended against any change to the law and made the distinction between the private area and said, well, the usual conditions about requirements for an easement must remain. But in relation to public rights in the nature of regulatory easements, then easements in gross can exist. So it's status quo as far as that's concerned. Okay, now I won't spend much time on the various ways that easements can be created. Safe to say the most traditional way was by an express grant, which was contained in a conveyance or a deed, and of course under the Transfer of Land Act an easement can be registered. The issue usually with the express grant of an easement is just what does it give the dominant tenement proprietor the right to do. It seemed a simple sort of point, but it's led to a lot of litigation. And in fact, one of the things that the Law Reform Commission was concerned about were the number of disputes that arose about just what some easements allowed the dominant tenement to do, or dominant tenement owner to do. And all too often, either the wording is vague or because of the changes, of course, in society, there are changing uses which then raise questions of, well, does reference to horses and carriages include tractors or buses or whatever? So there's those sort of issues. Implied easements, the rule in Woolden boroughs. James is another of those old 19th century cases, but it still seems to live on. The principle there is when you have a piece of land that may have had some use attached to it, such as a couple of buildings, and it's subdivided so that it does become two titles, one title might not be capable of enjoying the same benefits unless there's an implied easement, for example, in relation to light. It might be two buildings close together, one of them must need access to light to its down-storey windows, perhaps. And so a doctrine developed that if there were continuous and apparent easements necessary to the enjoyment of one of the properties conveyed, then there'd be an implied easement, with all the problems that go along with that as to how you define it and what it is. Now, the last category I've got there, prescriptive easements, again became a very important area of consideration by the Law Reform Commission. Prescriptive easements, as we all again remember from our law school days, were due to long user, so that there was no express grant, there's no plan of subdivision with an easement carved out. It's simply people have been using, let's say, a right-of-way, or what becomes a right-of-way across a piece of land for a long time. The period used as a rule of thumb these days is 20 years plus, so long as certain conditions are met as to user as of right, then a prescriptive easement can be created. I've got a couple of points there on that slide. One is that the High Court in a fairly early case didn't like the English doctrine of the fiction of the lost modern grant. In fact, that someone had actually granted an easement at some stage, but it had been, the grant creating the easement had been lost, so the court had to do the best it could. The High Court didn't like that approach, but nevertheless held that you could have easements created by long user. Now, what are the problems? Justice Hedigan, in a case called Sunshine Retail Investments and Wolf a few years ago, was faced with this fact situation where there was a block of flats at the end of a road, and what had happened over a number of years was that the residents in one street had used the side of the block of flats. There must have been an open area there where they'd pass to and from the next street because it was convenient to do that to get to the shopping centre and so forth, rather than go a long way round. I think the way this thing came to a head was there was some proposal to redevelop the block of flats, and access to the alleged right-of-way was going to be removed. And so a stoush developed, and the residents that have been using the access applied to have a declaration that there was an easement created by long user. Now, Justice Hedigan refused to declare there was a prescriptive easement because one of the main reasons was that because all the flats were tenanted and the owner was not in possession, he said, well, you've got to show that the owner whose interest is being affected is aware of what's going on. It's got to be a user as of right against the owner, and there's no doctrine that that's conveyed through the tenants. And therefore, there was no evidence that there'd been user as of right as against the owner of what would be the servient tenement. And for that main reason, His Honour rejected the claim. So it is difficult. Now, the other case that's interesting is the McMahon case. It's a decision of Justice Whelan fairly recently, where there were several sorts of claims in that case, but it also shows the problems that arise. That was a case where originally land was held in common ownership of down near Lakes Entrance somewhere, or the surrounding the lakes area. In a family, the father had wanted to provide for his children so they could enjoy this property. It was quite a large property. He divided it into a number of parcels and gave them all various bits and pieces, which was okay as far as it went. The problem was that to get to various parts of what was a composite property at one stage, you had to have access. And so fairly bitter disputes arose about the nature of the access and whether, in one case, whether aircraft could use a part of the land as an airstrip and so on and so forth. And it's an interesting discussion of prescriptive easements and implied easements and so on and so forth. And that probably is the most recent case which discusses some of these principles. But they're quite often fairly unhappy disputes about prescriptive easements. And the Law Reform Commission recommended the abolition of the doctrine of prescription. In this way, it said that what should happen is that existing rights should be protected. So if you had accrued rights by way of prescription, they would be protected under its proposal, but that going forward, there would be no more easements created that way. I think we'd all have problems about how you legislate that, and how do you provide for, well, drawing a line in the sand as to what's in and what's out is one problem. And the other issue is, of course, that if you're going to adopt a planning approach, it may not always be appropriate to all areas, particularly if you start talking about rural areas. There may be a better case there for easements by way of prescription than perhaps in the urban environment. Okay, so moving along, I'm going to cover all this. I'll do the best I can. Well, the big area these days, and the area which is creating a lot of problems, is the creation of easements under planning legislation, either by reservation on plans of subdivision, which we're all fairly familiar with, but also under sections 23 and 36 of the Subdivision Act, you can have easements created or removed by the operation of the permit process. And that's led to some very interesting and quite difficult cases. Well, what are these sorts of cases that come up as follows? Complaints about interference with easements. There's been some very hot disputes over alleged overuse, for example, of an easement. Claims about abandonment. At what point in time can you say, well, the easement served its time but no one's using it, therefore it should cease, and I want to get a declaration that it no longer affects my property that's burdened with the easement. And then the other issue, of course, is this tension with planning legislation where, under those provisions I just mentioned, the permit process can be used to vary or remove easements, and that's led to some very bitter disputes as well. Okay, now that was by way of going backwards, sorry to talk about the scope of easements. I simply mention that because it's led to one big area of disputation And the High Court principle is that you must be able to work out what the easement covers from its terms. You can't have a reference to external materials. And that, of course, creates a whole lot of problems, because one would think that the context in which the easement was originally created might be very relevant to its definition of its continuing use. So, faced with that sort of problem, because there are a number of cases where either the grant is very vague or the wording is too cryptic, the Law Reform Commission has recommended that there should be a series of statutory definitions of various types of easements, so that all you would need to do is to say, well, as it currently exists, an easement of carriageway is defined under the Transfer of Land Act in some detail, but to do the same thing in relation to easements of light or whatever, so that these types of disputes get confined. So that, I think, is probably a worthwhile recommendation. Again, the devil is in the detail of working out just how those descriptions would be prepared and so forth. Okay, well, over usage cases, as I say, they have become quite a difficult area for disputation, and the case which gives us the learning on that is a decision of Lord Denning called Gelbert and Davis, where originally the dominant tenement was a rural property, but as the ownership devolved, the new owner wanted to convert that into a caravan park for 200 units. And obviously that would create an enormous burden on the servient tenement, and Lord Denning held that that was way beyond anything originally in contemplation. Okay, now perhaps turning to the area of liveliest debate at the moment is this intersection with planning law. Section 23 of the Subdivision Act can allow an easement to be removed by the grant of a permit. It seems simple, but before you can do that, you've got to go through the planning process under the Planning and Environment Act. And of course, as we all know, that has an objection procedure. There are various rights of appeal. And so to use this methodology to get rid of an easement is not quite as easy as it might at first appear, because you have the responsible authority stage where you've got to get your permit in the first place. Having run through that, you then face the problem that objectors might take the matter to VCAT, and which is often where these cases wind up. And of course, that procedure itself has issues of delay, representation, so on and so forth. And so some of these cases have really become very difficult. And one thing which the Law Reform Commission became concerned about was that to use this procedure to get rid of an ordinary private easement rather than one that's, say, created under a plan of subdivision becomes it's a bit of a distortion of the planning process. And what VCAT recommends, the Law Reform Commission recommends is that Section 84 of the Property Law Act, which deals with the variation and removal of restrictive covenants, be extended to cover easements as well. And also that jurisdiction under that section should be extended to cover VCAT as well as the Magistrates' Court. So to give you an illustration of the difficulties that do arise if you try and remove a private easement under the Subdivision Act, I've given you the case there of Focus Division in Nillumbik Shire Council. It's a very bitter dispute. In that case, the easements were created under a plan of subdivision, and of course the owners of the dominant and servient tenements, I think, were no longer connected with the original owners. But the owner of the servient tenement wanted to build, or had built a property I think, near the crest of a hill because that was the best place to build it, but it also happened to be very close to the easement. And a rather nasty confrontation developed between the owners because the dominant owner wanted to use tractors and machinery. It's a semi-rural property, moving quite close to this home. And so the servient tenant and owner applied to have a permit with the effect of trying to remove the easement. Now, it's a very well-reasoned decision. Michael McNamara was then the deputy president of VCAT. I think he wrote the judgment essentially because it was done by the legal member, and he canvasses all the problems of using this particular section in this context and saying, well, it's not really appropriate to resolve private disputes about easements. They really need to be dealt with under the general law and under the well-known principles, and to try and use the planning legislation to do it is a bit of a distortion, because there's no sort of roadmap under those sections about things like compensation or what considerations the tribunal must have regard to. So look, I'll skip through those slides. You can read about the issues that arose there. I've also given you another case, Preston Corporate Centre and Darebin City Council, which is a successful case where the procedure was used in a proper planning sense when you had a redevelopment for, I think it was a Bunnings site or something like that, and obviously the rights had to be sorted out, and the VCAT had no trouble giving effect to the permits in that case. So you've got the contrast between the private dispute, which is quite bitter, as opposed to what is more realistic planning situation, which is properly dealt with. Okay, now I think I'll skip these and try and say something, if we can, about very briefly about abandonment claims. The difficulty with these claims, I think, is illustrated by Riley and Pentilla, which is quite a famous case where you had a leafy suburb where the developer of the land had created this very nice, I think it was like a circuit where all the properties backed onto a park, and they were all given rights by way of easement to use the park. Very similar to the old English model. Well, one of the owners decided that no one was really using this easement, so he would fence off part of the land and put a swimming pool in and just extend his own property. And of course the other owners became a bit upset about it, and he had a very nasty dispute. And the Supreme Court held that the easement had not been abandoned just because there may not be full user or user of the easement for some period of time is not conclusive. You have to show that there's been an intention of the dominant owner not to press any rights, but to perhaps just give up using, and there's some indication that for whatever reason they no longer want to use the easement, perhaps because their use of their own land has changed. Well, there was none of that in that case, and I think if you're looking for a case on abandonment, that's probably the right place to start. Now, I think time is going to be very short for talking about restrictive covenants, but I would like to draw your attention to a couple of recent cases dealing with a variation or removal of restrictive covenants. Now, I won't go over the doctrinal basis or enforcement, but okay, so where do you go to remove a restrictive covenant? The main source is Section 84 of the Property Law Act. As I've said, the Law Reform Commission wants that jurisdiction to be expanded. There are three categories for removal under Section 84. 1A, which is where you say that the covenant has become obsolete and that continued existence would impede the reasonable use of the land. The next category is where there's a consent in effect to the discharge or modification. Of course, one doesn't see very many of those. And C is where the proposed discharge or modification will not substantially injure the persons entitled to the benefit of the restriction. That's probably of A and B. That's probably the better way to go. The first one can be difficult because you've got to show that the thing is absolutely worn out, and you've got to show that it would impede all reasonable uses, not just one use. So the case on 1A that I'd give you is Sir and Mitchell Moore, and it shows the tensions between, in a planning sense, it had Sir Edmund Herring owning this property in 1937 in Wall Street, South Yarra. He had the benefit of a restrictive covenant on the property next door, which had a height restriction so that Sir Edmund's view of the parks and the river would not be impeded. One could understand that. However, of course, in the context of the 2000s, the whole character of the area has changed and people want to put up bigger buildings, perhaps build blocks of units and so forth. Came before Justice Pagoni, and he had to construe the covenant to start off with. He looked at the High Court decision in relation to easements as also informing the interpretation of the construction of covenants. And so there's that point. He also then went through the two limbs in section 84(1)A, the obsolescence limb. It's a question of fact as to what the changes in the character of the neighbourhood are, etc. And then the second issue about reasonable user, and the problem there being that we must impede all reasonable uses. So what you get in a case like that is substantial evidence of user, expert evidence and so on, so they're quite expensive cases to run. In any event, the decision came down that it was reasonable to vary the covenant, and then of course there had to be a lot of negotiation about how the covenant would be varied. So that's a good source on that particular limb of section 84. The other case I take you to, which is a very recent one of Associate Justice Derham, is Wong and McConville on subsection C. Now that's on the basis of not creating, will not substantially injure the parties that are entitled to the benefit of the covenant. And the great thing about this particular judge is that he sets out comprehensively all the relevant principles. So if you want a case on this area of the law, this is a very good place to start. So he goes through the test. You've got this comparison test. What's the situation going to be if the amendment's allowed to go through? What will the covenant look like? What will the land use look like? What's the effect of substantial? And again, you still need lots of factual and expert evidence in these sorts of cases. The great thing about this judgment also is that His Honour sets out the covenant and the proposed variation to it. He sets out a whole lot of other information from the evidence. So as I say, it's very comprehensive. Just to close off, I think I already mentioned the removal of easements under this section is a possibility if the Law Reform Commission report is adopted. A couple of other points there. I think we're running very close to time. Okay, well, just to end off, I spoke to Justice Croft the other night very briefly about the report because I'm interested in whether it's going to be adopted or not. He had no particular information. As we all know, I think this sort of law reform can be very slow. The other problem is that the Law Reform Commission has also reported on reforming the Property Law Act. So it will be unlikely, I suspect, that there'll be a partial reform to carry out, say, the easements and restrictive covenants reforms without some additional reform of the Property Law Act. So maybe we will get a blockbuster sometime in the next few years. Obviously, the current political climate in Victoria is not looking at reform of property law just at this moment, but let's watch this space and see what happens. I'll just end it there, I think, John, in case there's any discussion or questions.
Thank you very much, both David and James. Thank you very much, all of you, for coming and attending this breakfast briefing. See you next time.
Thanks, John.